In this video, I'm going to talk about your judge is not your therapist. Okay. And it's very, very important that we not confuse the two. So many people go in and they want to be heard. And one of the things my late husband Thomas used to always say is, do you want to be heard or do you want to win your case? Because usually you can't do both. Okay. Our emotions drive us a lot when we don't even realize it. And so I'm going to help you in this video determine, are you coming at this from an emotional perspective that you should be talking to your therapist about, or are you really coming at this from what the judge wants to know from you? Before we dive in, let me just remind you, if you like this content, you find it helpful, don't forget to hit like on this video. Also subscribe to the channel so that you get notified as new videos are released. When we go in and we start just telling our story, some people would say, well, what's the problem with that? Like, the judge needs the background and the judge, needs this and that. And, this is, I think, more challenging when you're self-represented. If you have an attorney, you're not going to get a chance to say as much, unless you're in a hearing where you're testifying or something like that. But those are usually scheduled and that's coming and all that kind of thing. Usually in a regular motion hearing, we're not doing a lot of talking. The judge might ask you a couple of questions, but they usually tend to be more logistical and not kind of a open-ended, what's your story kind of question. It'll be like, well, what time do you get off work? Or, how far is the distance between your house and the other parent's home? Or something really specific like that. But if you're self-represented, then, you're kind of given an open floor, right? In a certain way, like an attorney would be given if you had somebody representing you. And when we're talking, again, we tend to want to give our whole story. And this isn't just when you're standing in front of the court. A lot of times this is with, you might be going to mediation. In California, we have mandatory custody mediation. And so you're in front of a mediator for that. Sometimes we're in front of an evaluator. We have that also. Or you're in front of a guardian ad litem, which I've talked a lot about recently, or some other kind of expert like that. And this applies in all those situations. But I think people really get themselves in the most trouble in court when they are self-representing and they're handling their own case. So what happens is you just start giving your whole background. And part of the reason is because when you first go on this kind of journey into court, especially if you're somebody that's never really had a court experience before, which is how I was when I first got my divorce. And you go in and you don't realize how quickly this hearing is over. Like, you go in and 15, 20 minutes is 30 minutes. That's a really, really long hearing. Many of these hearings are done in 5 to 10 minutes. And if you stand up and you start talking about how you walked 12 miles in the snow one way to school when you were a child, so to speak, that judge is going to cut you off pretty quick, because it's going to be like, I don't need to know all that. That's not part of the consideration of what they're deciding. So if you're in and they're deciding on custody or some issue like that, and you start going into the background of your whole relationship with the other parent and all these types of things, you're going to get cut off. And then they're not going to allow you to talk as much. And that can kind of set the tone for in the long term for your case, right? Because you're not just standing in front of this judge right now for this one hearing. Most of the time, you're going to have multiple hearings in front of this judge. Now, I hope not. I hope you get into mediation or use some kind of alternative dispute resolution or something. But a lot of times when we're dealing with a high conflict person on the other side, and we're dealing with those types of, narcissistic behaviors and high conflict behaviors, a lot of times we do have multiple hearings and we are in front of the same judge over and over again. So if you set the initial tone as, I'm going to stand up here and tell you everything that's running through my brain, then every time you come in front of that judge, they're going to go, oh, this is the person that wants to tell me everything that's in their brain. So I got to make sure I cut them off early, because I don't have 30 minutes to sit here and listen to them give me their whole sob story, right? And not to say that a judge doesn't care. They care. But we have to understand that judges are there to solve problems, okay? They're there because we have disputes and they are there to solve those disputes, right? It's kind of like, think of it in like contractual um, perspective, not relational. And I think that that's a big difference because we come into family court and we're looking at things from a relational perspective, right? Our spouse, our children, the ways that, the other person has hurt us or harmed us emotionally or whatever the case may be. And the court is kind of coming at it more from a business type contractual perspective. Okay, these two people had a contract of marriage. That contract has now broken down, or maybe you didn't have a contract of marriage. Maybe you just had a child together, but having a child together, creates certain obligations in the state that you live in, right? Or wherever you reside. There's certain contractual things that are in place as a result of that. And so the court's going, okay, these two people are not together. So this contract is no longer happening in this way. How do I make, everybody whole, so to speak, according to how the state deems I should do that, right? So if you live in a state like California where they look at 50-50 custody to each parent, barring any health, safety, or welfare concerns, then that's the perspective that the court is going to take in trying to make the two parties whole, right? The way I make the two parties whole is 50-50 custody, unless there's some extreme outlier that gives me a reason to flip that because the child safety is in danger or the parents logistically live too far apart or whatever the issues might be. But again, the court's coming at this from a perspective of how do I solve this problem, not what did one person do to the other, or what is the whole background of this story, so that I can try to take into consideration every way that each person has been wronged in this situation and try to make amends for it. They're not coming at it from that perspective. And a lot of states, we no longer have affairs, or adultery is no longer an issue in California. At least I know there's a handful of states that still have grounds, but most states don't have grounds for divorce anymore. So those types of things just don't come into play like they used to. And so the court isn't there to decide who's the good person and who's the bad person. They're there to decide, okay, what should the parenting plan be? How much support is going to flow? And if you're married, what's the division of your assets and debts? And then I'm going to divorce you. And that's what the court is there to decide. So when you come in and you want to give the whole background of everything that transpired during the relationship or the breakdown of, the court is in their mind going, okay, none of this is relevant. And the longer that you talk about things that are not relevant, the more likely you are to then get cut off. So what I always try to help clients do is, okay, let's focus in on what are the key things that are actually going to move the needle for the judge. What are the things that are actually going to influence them, that they're going to care about? And then put that into, and if you're trying to figure out what that is, go look up best interest of the child for your state. That's the first thing that the court's looking at, best interest of the child. So you need to understand what that legal definition is, because it's not just what you think is in your child's best interest. Okay. It's actually a legally defined term. And I say that frequently. So once you figure out what that is and what the actual information is that's going to help the judge come to the conclusion that you want him to come to, then what I always tell people is write it out. Especially if you're self-represented, write it out, stand in front of a mirror, read it, time yourself, know how long this is going to take, because you maybe have 3 to 5 minutes probably before you're going to be cut off in a regular motion hearing. If you're going in for an emergency hearing that somebody filed and you're getting in like quick within a couple days, those are even shorter. So you got to pare it down even more. So understanding what type of hearing it is, what you're there for, about how long that you're going to have, and what is the information that is actually going to help your case, and not what information do I feel so many times clients say to me, oh, I just want the judge to know. Okay, no, that's probably the first thing you should cut. Anything that in your brain you're going, I just want the judge to know, meh, that needs to be cut out, because that's not what this is about. This is not about making sure the judge knows how you were wronged or knows how you feel. It's none of that. It's what things are relevant for the judge in making these decisions and making the decision that I'm wanting them to make. Okay. When you start to connect that and understand that concept, especially if you're self-represented, you will have far more success in your case. But honestly, even if you have an attorney, what will happen is you'll start to understand what information is helpful for you to provide to your attorney and what information is not. I have had clients come in that have spent thousands and thousands of dollars feeding information to the attorney that they began to understand wasn't even relevant. And I think this happens more commonly in the very beginning when we're emotional and we haven't learned as much about the process. And I frequently see clients 3, 6, 9 months into this process where they just start to go, oh, I'm starting to get it now. I'm starting to understand, and this is why I always tell people, like, I do my coaching services over a period of time, because a one-time, touch point with you isn't really going to educate you on what you need. You need to understand this process, and you need somebody that's walking along with you through it to help you navigate and further your education at each stage, so that you can make sure that you're advocating for your and your child's needs. So if you'd like help with that, you can go to divorceuniversityonline.com/VIP-coaching. There's information on that page on my group coaching programs for moms and for dads. There's a video on there that you watch, and then it will give you the information on those programs. And then at the end, it will also give you an option to book a free consultation with me if you're interested in my VIP coaching services. These are premium level services designed for a high level of support in really complex cases, or for clients who just want a really high level of hand holding and understanding and support as they're moving through this. Okay. So go over, check those out, figure out which one will work best for you. And I will see you guys next time.